The Civil Rights Act of 1964 was passed by Congress and signed into law by President Lyndon B. Johnson on July 2, 1964. This law prohibits discrimination on the basis of race, color, religion, sex, or national origin. Provisions of this act forbade discrimination on the basis of race and sex in hiring, promoting, or firing. This act also prohibited discrimination in public accommodations and federally funded programs. Title VII of the Civil Rights Act prohibits employment discrimination based on race, color, religion, sex, and national origin. This law prevents employers from engaging in unlawful employment practices, such as failing or refusing to hire or discharge any individual or otherwise discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of a protected class characteristic, or limit, segregate, or classify employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect status as an employee because of a protected class characteristic. Title VII protects employees who work for all private sector employers, local, state, and federal governments, and educational institutions that employ 15 or more individuals. Title VII also applies to private and public employment agencies, labor organizations, and joint labor management committees controlling apprenticeship and training. Title VII of the Civil Rights Act is a federal law. While some states have adopted their own state laws that largely mirror federal law, some states have expanded beyond federal protections, and other states have not implemented any state-issued protections for certain categories. The state of Michigan has the Elliott-Larsen Civil Rights Act, which prohibits discrimination in employment, education, housing, public accommodations, and public service. The Michigan Department of Civil Rights accepts complaints based on unlawful consideration of religion, race, color, national origin, arrest record, genetic information, sex, age, height, weight, marital status, and disability. The state of California has the Fair Employment and Housing Act. Under California state law, it is illegal for employers of 5 or more, compared to the federal law's 15, employees to discriminate against job applicants and employees because of a protected category, including race, color, national origin, religion, age, disability, sex, gender, sexual orientation, gender identity, genetic information, marital status, or military or veteran status. California also has progressively led state-mandated sexual harassment training requirements for private sector employers. Alabama does not have a statute that covers anti-discrimination issues. However, it does have a statute that covers age discrimination claims against employers who have 20 or more employees. Employees in this state are instead covered solely by federal law. In 1980, the Equal Employment Opportunity Commission issued regulations defining sexual harassment as a form of sex discrimination prohibited by Title VII. For harassment to be based on sex, it need not be an act motivated by sexual desire or result in sexual conduct, but rather the harassment must be gender-specific. Types of sexual harassment can include quid pro quo or hostile work environment. Quid pro quo occurs when a favor or advantage is granted in return for something. Typically in reference to sexual harassment in the workplace, it occurs when a supervisor uses the superior position to extract sexual favors from a subordinate, and retaliates by taking adverse employment action against the subordinate if the harassment is not well received. A hostile work environment can be created by managers and supervisors, co-workers, or third parties such as customers and clients. It can result from a wide range of verbal conduct, including insults, epithets, tasteless jokes, profanity, and requests for sexual favors. Physical conduct, including touching, exposure, staring, stalking, sexual assault, and rape. And displays of images, including pictures, posters, emails, websites, and pornography. The key issue is whether an employee is subjected to unwelcome, offensive treatment because of his or her sex. The basic standard permits that harassment must be sufficiently severe or pervasive to be actionable, with severity covering the degree of harm posed by particular acts, and pervasiveness covering the frequency of harassment. Conduct that is physically threatening or humiliating, or that unreasonably interferes with an employee's work performance, reaches the threshold for a legally actionable hostile environment. Compliance with Title VII of the Civil Rights Act is enforced by the Equal Employment Opportunity Commission. The Commission is responsible for issuing regulations that interpret the law, which define important terms used in the statute, establish procedures for enforcing employee rights, and provides information so that both employees and employers are clear on their rights and obligations under law. Additionally, employees alleging violation of Title VII can file a charge of discrimination with the Commission within 180 days of the discriminatory conduct. A charge of discrimination is a signed statement asserting that an employer, union, or labor organization engaged in employment discrimination and requests that the EEOC take remedial action. Employees who file a charge of discrimination can expect the charge, if accepted, to go through the process of mediation, in which a mediator attempts to help both parties reach a voluntary settlement, or investigation, which includes fairly and accurately assessing allegations of workplace discrimination. Investigators may collect extensive information about the situation from the employer and employee, or a third-party witness, as well as conduct interviews with all involved parties. Investigations typically take around 10 months. The Equal Employment Opportunity Commission has an enforcement plan to eliminate discrimination in the workplace that includes prevention through education and outreach, which can include giving presentations to employees and employers, voluntary resolution of disputes, which can include mediation, and where voluntary resolution fails, strong and fair enforcement, which may include investigation, resulting in potentially a lawsuit, a consent decree, or requiring employers to provide injunctive relief within the workplace. The Equal Employment Opportunity Commission filed suit against Del Taco in the U.S. District Court for the Central District of California, alleging that at least 3 male employees, including those in supervisory roles, at its Rancho Cucamonga area stores violated federal law by subjecting young female employees to sexual harassment and related retaliation. Sexual harassment came in the form of unwelcome physical contact, vulgar comments, and propositions for sex. Behavior was so prevalent that other male employees felt free to engage in sexual harassment as well. Retaliation came in the form of changing the schedules and reducing the working hours of those who complained of harassment, forcing them to resign. Some women made formal complaints to management and human resources within the company, but no action was taken. Such conduct violates Title VII of the Civil Rights Act of 1964, which prohibits sex discrimination, including sexual harassment and retaliation. A 3-year consent decree implemented company-wide injunctive relief aimed at preventing workplace harassment and retaliation. As a result of this decree, Del Taco must provide monetary relief in the value of $1,250,000, retain an Equal Employment Opportunity Monitor, review and revise its policies and procedures on discrimination, harassment, and retaliation, create a structure for employees to report discrimination and harassment, and provide training to all employees on anti-discrimination laws with an emphasis on sexual harassment. The Equal Employment Opportunity Commission filed suit against Activision Blizzard on September 27, 2021 in the U.S. District Court for the Central District of California, alleging that the companies Activision Blizzard, Blizzard Entertainment, Activision Publishing, and King.com, as well as the entity's subsidiaries, violated federal law by subjecting female employees to sexual harassment, pregnancy discrimination, and related retaliation. Sexual harassment came in the form of unwelcome physical contact, as well as verbal harassment. Pregnancy discrimination was seen with employees having their medical restrictions ignored, as well as being provided negative performance evaluations while on maternity leave. Retaliation came in the form of employees being deprived of work on projects, being unwillingly transferred to different units, and being selected for layoffs. A 3-year consent decree was implemented throughout the companies located in California, Wisconsin, New York, Minnesota, Texas, and Arkansas following conciliation discussions. In the settlement, Activision Blizzard agreed to injunctive relief aimed at preventing workplace harassment, discrimination, and retaliation. The companies agreed to provide monetary relief in the form of an $18 million settlement fund for harassment and discrimination victims, have a neutral third-party equal opportunity consultant as well as an internal equal employment opportunity coordinator to ensure compliance of the decree, submit to unannounced audits of current employees to assess whether issues of harassment, discrimination, and retaliation are being effectively handled, provide anti-harassment and anti-discrimination training that includes bystander intervention, and evaluate their disciplinary framework and protocols to ensure actions taken lead to effective preventative measures. Suggestions for employers that will assist the organization in being compliant with the controlling law include implementing a strong equal employment opportunity policy that is embraced by all levels of the organization. Policies and practices should be related to the job and should not disproportionately exclude those of a protected class. All employees should be properly trained on workplace equal employment opportunity policies and practices, as well as equal employment opportunity laws. Workplaces should promote an inclusive culture in the workplace with an emphasis of professionalism and respect. All members of the organization should refuse to initiate, participate, or condone discrimination and harassment. Workplaces should foster open communication and early dispute resolution. Employers should establish neutral and objective criteria to avoid subjective employment decisions based on hidden biases, and they should also conduct self-analyses to determine whether current employment practices disadvantage those of protected groups or treat them differently. Employers should also adopt a strong anti-harassment policy and train each employee on its contents. A strong anti-harassment policy should include a clear explanation of prohibited conduct, including both verbal and physical conduct, assurance that employees who make complaints or provide information related to complaints will be protected against retaliation, assurance that employers will protect the confidentiality of harassment complaints to the furthest extent possible, a clearly described complaint process that provides multiple accessible avenues for filing complaints, a complaint process that provides a prompt, thorough, and impartial investigation, and assurance that the employer will take immediate and appropriate corrective action should harassment occur in the workplace.